Hello, everybody, and good afternoon. It's attorney Laura Sterling here. I'm doing, as I promised, my December Live. My December Live, I like to kind of do a summary. I like to get you prepared for January 1st of 2025. Can you believe that? 2025. Anyway, I like to make sure, as I always call it, your things and stuff are in order, right? Your things and stuff. What does that include? That means all your personal belongings, your tangible property, your money, your property, whatever it may be, that it's in some kind of order, that you know you can go into 2025 going, okay, I did what I needed to do to ensure my loved ones are taken care of. Or it doesn't even have to be loved ones. It can be charities. I have lots of people that donate money in their estates to charities, Animal Allies, or hospice, or something like that. That's your choice as well. But I'm here today to talk about how we can protect your things and stuff. Now, I've only got a couple weeks now until the end of the year, right? It's December 17th. How many days until the end of the year? It just flies by, right? In fact, today's my wedding anniversary. FYI, see how time flies when you're having fun? Anyway, make sure that you keep track of time, because I get lots of clients that come to me and they want to do something. And why they want to do something with their things and stuff is because they had a loved one close to them pass away and that person didn't have their things and stuff in order. And so that meant the surviving individual that has to take care of it has a mess to clean up. So let's start out with number one. Let's talk about a will. What is a will? Now, people always understand that I'm in the state of Florida. So I'm going to talk about Florida law and how it pertains to wills and how we distribute things here in the state of Florida. If you're outside the state of Florida, if you're in another state in the United States, or maybe you're in a different country, it would be a good idea to get with an attorney in your state or in your country to find out, because they're all different. Although my father says, oh, but they're kind of similar, aren't they? No, no, no. I'm only licensed in Florida. I can't give you advice in another state. Here in Florida, we go, I like to describe it as the bloodline. We go with the blood. So what does that mean? Let's say, well, I have my will, but let's pretend I didn't have my will. And God forbid I went out and I died today. What does that mean? That means that everything is going to go to my husband. Or if I don't have a husband anymore, maybe my husband passed away before I did, it's going to go with the blood. Now, the blood either has to go up or down. So if it can go down, meaning my heir, my child, the blood can flow down, it's going to flow down. But what if I didn't have any children? What if my husband passed and I passed and I didn't have any children? The blood tries to go down, but it can't. Think of it like a clogged artery. It can't go down. So what happens if it goes down? It can't go down. What happens if it goes up, right? So it goes up. My parents, what if my parents are deceased? Then what? Clogged artery again. It can't go up. Now what does it do? It goes out. So who's out? My siblings. Let's say both my brothers are still alive. So my share or my estate is going to be split 50-50 with my siblings, because I can't go down and I can't go up. Now, if I can go down, but let's say, I don't even want to think about it. Let's say my child was not there to get the benefit, then whatever his children. So it'll keep going down till it can stop. If it can't go down because there's nothing to go down to, it'll go up and then it'll go out. So think of that here in Florida: down, up, out. It's like a T. It's kind of like a backwards T, I guess. You're making a T. But if it can't go down, it goes up. If it can't go up, it goes out. So with a will, you're able to name what we call a personal representative. And what is a personal representative? Personal representative is somebody who manages your estate, who's listed in your will, and who manages your estate when you pass away. And what does that mean, manage? What does that mean? Well, they have to go to court. They have to file a probate. They have to get appointed as a personal representative. And they're given orders, court orders, so they can go to my bank or to my mortgage company or to my whoever it may be, my creditor is saying I have the authority to act on her behalf as her personal representative. So think about it. We'll talk about this next year, 2025, power of attorney. A power of attorney is who I appoint to take care of things for me if I'm unable, right? But that power of attorney dies when I die. So then it reverts to a personal representative. So think of a personal representative as a power of attorney, except the only clause it's missing is me because I'm deceased. So I have to tell you a story. As you all know, I'm a licensed clinical social worker and I worked nursing homes for 10 years before I became an attorney. And I remember we had a family. There were many children. I think there were like 5 adult children. I don't even remember. All I know is there were a lot. I remember a lot. One had power of attorney, and then when mom passed, a different child had personal representative, was appointed personal representative as the mother spelled out in her will. Well, they both came into the facility. I don't remember why. One holding up the power of attorney paper and one holding up the personal representative. When you pass away, like I said, that power of attorney dies. So we had to tell the son with the power of attorney, I'm sorry, we can't help you. Your document is no longer valid. We're going with the personal representative. So I always tell my clients too, when you're nominating somebody to be a personal representative, know it's somebody you can trust, know it's somebody that can handle the stress and dealings with all of everybody they have to deal with, the bank, the mortgage, whoever, that they are able to do that. Because if they can't do it, then what? Then somebody else has to come in who wasn't appointed to be that personal representative. I also tell my clients, when you appoint that personal representative or you name that personal representative in your will, make sure that you have a backup. Because what if something happens to that first person? You want to make sure you have a backup so nobody has to scramble and decide who's going to be personal representative. So a will divides your things and stuff, okay? It divides your stuff. And what has to happen in a will is everything in your estate that's in the will, that's named in the will, has to go out, meaning it has to be distributed. You can't in a will say, well, no, I want like $10,000 to be held back for my son in the event that he gets married. You can't do that in a will. You can't put something in a bank and hold it there till something happens in a will. A will has to empty out. Think of it as emptying out and then close. And then never be looked at again. Hopefully, there's not a dispute, but a will has to close. Now, there's another document. If you came to me and said, but listen, I don't want everything to go to my kids right away. At one time, I had a woman that wanted to set up what we call a trust, a trust. And what she wanted to do with that trust is she wanted to spell out, she only had one child, just one child, and that child was in their 40s. So that was the only child she had. She wanted to sparsel her estate out to her over several years. And I kind of remember kind of scratching my head and going, you realize your daughter's 45 years old. Like, she's not a spring chicken, right? 45 years old. How long do you plan on spacing it out? And my client's thought process was, I don't want my daughter to think she doesn't have to work because she has this money waiting for her. I said, okay, I'm with you. I don't care what the reason is. I was just a little perplexed. But a trust allows you to kind of disperse it as you feel right. Meaning it gives you more control, even after you've passed away, to make sure that certain people get certain things. For example, like I said, I want the 45-year-old daughter to get it over time, or I want my son to get it if he ever gets married. Or sometimes what they do is they say, okay, I want them to get it when they turn 18. I want them to get a certain amount, maybe let's pretend 5,000. I want them to get 5,000 when they graduate from college. I want them that you can do that with a trust. Hello, Nicole. If I am married and my parent passes away and I get money from the estate, do I have to share that money with my spouse? I like how you say that, Nicole. That's a good question. I get that a lot. Sometimes what we do as parents, and I don't know if you're a parent or not, but sometimes what we do as a parent, we love our children. We love our children. But sometimes our children don't always pick well, do they? So we say, hey, we want to make sure that the spouse doesn't get it. So maybe that's another reason why you put it in a trust, to say, hey, I just want it to go directly to my child. I don't want it to go to anybody else. Now, you don't, let's pretend you don't have that, Nicole, okay? Your parent passes away, you get $20,000. Now, that in and of itself in Florida is non-marital. That inheritance is non-marital until such time as you take that non-marital inheritance and put it in your joint bank account. Now it's marital because you've now subjected it to the marital, what do I want to say? The marital assets, because you've put it into your joint bank account. Or you put it into your own account with your name on it and you start using it in the marriage. Now it becomes marital. And yes, in the case of a divorce, I'm not saying anybody's going to get a divorce, but in the event of a divorce, the spouse can then lay claims to that inheritance as part of the divorce settlement. But, between you and your husband or you and your spouse, whoever it may be, if you want to give some to your spouse while you're still married, that's totally up to you. Or make it marital, that's completely up to you. But an inheritance does not automatically become marital just because you get it. So good question, Nicole. Good thought process of thinking forward. I like that. But anyway, a good idea as well is to put it in a trust in your own name and dole it out as you wish. Now, a trust understanding is a revocable document as long as you're able to make changes to it. So if you put your home into the trust in the name of the trust, and then later on you decide, I don't think that's a good idea. I want to take it out of the trust. You can. I can, in my own trust, the Laura L. Sterling Irrevocable Trust, I can take anything I want in and out of it because I'm the trustee, I'm the settlor, I'm the grantor. I can do whatever I want. If I become incapacitated or I pass away, it becomes revocable. Think of it as this chain around it. It can't be changed. It cannot be changed except by the terms of the trust. So I would, in my trust, direct my new trustee or my successor trustee as to what to do with those items that are in the trust. Dole them out this way, keep them this way, all of those kind of things. So that's what I would do. My trustee can only do what's in the trust. Can only do what's in the trust. So that's it. They can't do anything more. The only thing they can do more is the trustee has a fiduciary duty to the beneficiaries. So my trustee, whoever that may be, has a fiduciary duty to, let's say my beneficiary of the trust is my son. They have a fiduciary duty to my son to make sure that the assets in the trust are worth the money that is in the trust. Let me give you an example. Let's say I have a beach house. Oh, let me think about that for a second. I have a beach house, right? And that's part of the trust. I pass away, that beach house is in the trust and it's to go to my son. And so it's worth, let's say 2.9 million, right? It's a beautiful beach house. Let's say another hurricane comes through and devastates it. And now the trust is having to come out of pocket at astronomical rates of money to try to keep that house up. My successor trustee can go, wait a minute. My fiduciary duty is to protect the corpus. We call the corpus of the trust, what's in the trust, and make sure that we're not allocating too much to one asset or allocating not enough. So at that point, then the trustee would have a fiduciary duty to discuss with the beneficiary, hey, look it, this is what it's doing. It's eating all of the corpus, all of the cash out of the trust to maintain this one trust asset. What do you want to do? Because they can't really make that decision on their own. They need to consult with people. They need to first and foremost consult with the beneficiary because, like I said, they have a duty to that beneficiary to protect those assets. I try to explain that to my clients all the time. I go, listen, doing this, you got to make sure the ramifications. And therefore, when you're picking a successor trustee, again, make sure it's somebody savvy. My family, my younger brother is an accountant, got his MBA. He's a perfect one. Oh, Nicole. Oh, another question I have is what happens if I die without a will? Well, in Florida, like I said, it goes by bloodline. So if you pass and then wait a minute. And then if, excuse me, if you pass and you're married, then it would go to your husband or your wife, whoever your spouse is. If you're not married, then it's going to try to go down to your children. If you have no children, hear that hard knock, 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 it can't go down. So then it would go up. If it can't go up to your parents, then it's going to go out to siblings or nephews or nieces or cousins. We start calling those laughing heirs when we get beyond kind of that sibling point to the nieces, nephews, cousins, down the row. Just like with Prince, when Prince passed away, he passed away with no will whatsoever, right? And so, they just recently settled that. I think this year they just settled it. And how long has he been deceased? Because he didn't have anything in writing. And so what ended up happening is all these, well, I wouldn't even call them laughing heirs. Like they were no heirs. Like they had over 300 and some people try to lay a claim on Prince's estate, and they ended up with six. They were half siblings that he had, and there were six of them. Three of them sold their share to his estate to a company, which you can do, and the three others they held out. So those three others got to split whatever their share was, and then the company of the other heirs, they got to benefit from that. So you want to try to avoid that kind of fight, that kind of litigation, trying to figure out who they should leave it to, who they should not, who's related to, who's not. Because I'm telling you, number one, people will fight over $1, whether it's $1 or $1 million. They're going to argue about it. So it's always best to have things in writing. I want to give another example before I let you go. Elvis Presley. Elvis Presley died with a will. He died with a will. He had a trust. He had everything in order. So when he passed, it went to Priscilla. It went Priscilla as a trustee for trust of Lisa Marie. So what did Lisa Marie do when she got older? She did the same thing. She created a will. She created a trust. She put her children. She has 3 children, I believe. Only one's an adult, though, and the 2 others are minors. So the adult trustee is her oldest daughter, who is then the trustee, has a fiduciary duty to the 2 younger siblings. So that was as smooth as can be. There was a little, what do I want to say, from Priscilla. Priscilla she did act up a little, but not for very long, because they shut her down pretty quick, because she put everything in writing. Everything was sealed. Everything was great. So it was a much smoother process than years and years of litigation with Prince. So good question, Nicole. It's always good to have a will, because you want to be in charge of where your things and stuff go. You don't want somebody else to be in charge of telling where your things go. And you can name anybody as a beneficiary as you want, Nicole. Exactly right. But guess what? You may get a fight from somebody, but you're gone. And that's how it works. So anyway, as you know, this month, December, I'm talking about things and stuff. So stay tuned for my next live. I'm going to talk about power of attorneys. I'm going to talk about living wills. There's a difference there between a will and a living will. So make sure you stay tuned, and I can give you all the lowdown on power of attorneys, living wills, healthcare surrogates. And of course, if I don't see you before, have a wonderful and Merry Christmas. And I hope it's filled with love.